Hello everyone, welcome to Law and. Today we will go through the stages of civil suit as per Civil Procedure Code of 1908. Let's go by an illustration. Mohan wants to file a civil suit against Shyam. In this case, Mohan becomes the plaintiff and Shyam becomes the defendant. Mohan asks you to guide him through the stages of the civil suit. First of all, as a lawyer, you should know that the stages of a civil suit are established as per the Civil Procedure Code of 1908, in short, CPC. Under CPC, Order 7 states about the plaint. Plaint is a written complaint or allegation. We need to remember that the entire legal proceedings under the civil law begins once the plaint is filed. So, filing of plaint against Shyam is the first step which Mohan has to take to open a civil case. Next is service of summons as per Order 5 of CPC. After receiving the plaint from the plaintiff, that is Mohan, now it is the work of the court to start with their civil proceedings. The court will issue the summons to the defendant, that is Shyam, informing him that a particular action has been initiated against him and therefore he is required to appear before the court on a particular date and time to answer the claim in such an action. Accordingly, on the stated date and time, the defendant or his lawyer must appear before the court and answer all the questions. This is the third step. However, if the defendant or his representative is absent on that fixed time slot, the court may pass a decree against the defendant without hearing him. This is called ex parte decree. Ex parte decree is mentioned under Order 9 of CPC. Another matter which we need to know during this process is about the concept of written statement, which comes under Order 8 of CPC. Written statement is nothing but a reply given by the defendant to the plaint in a written form. In the written statement, the defendant either denies or admits each and every allegation or facts given in the plaint. According to Rule 1 of Order 8 of CPC, the defendant has to present the written statement within 30 days from the date of service of summons on him. But on the discretion of the court, the period can be extended up to 90 days. If the written statement is not filed within the specified time, then the court may pass a decree against the defendant. After the filing of the written statement by the defendant, the next stage of the civil suit is production of documents. Here, both the parties, that is plaintiff and the defendant, have to file all those documents to the court which are relevant to their case and on which they rely to support their stand. After this, under Order 10 of the CPC, examination of the parties take place. This stage is also called as first hearing. Here, both the parties have to appear before the court and the court shall ascertain from each party as to whether the party admits or denies such allegations of facts as are made in the plaint or written statement. Such admissions or denials shall be recorded. Next comes discovery and inspection under Order 11 of CPC. There may be some relevant documents to the case which are not there by one of the parties, but that party knows that the opposite party is in possession of those documents. Then the party who wishes to get those documents for the smooth functioning of the case can apply to the court asking to order the other party to submit them. Similarly, if one of the parties needs any answer from its opposite party, then they can interrogate or ask questions in the written format. Don't confuse this step with cross-examination and trial. Cross-examination and trial are different concepts and they come in the later stages. Remember that in discovery and inspection stage, everything will be in writing. Now, let's come to the admission stage. Under Order 12 of CPC, any party to a suit may give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case as stated by the other party. Next comes the stage of framing of issues under Order 14. Framing of issues is a work of the judge. In simple meaning, framing of issues means framing of the questions or the topics on which the judge seeks exclusive clarity by the parties. One party may say that a particular concept exists, but if the other party denies it, then the judge frames an issue on that particular concept. So matters are later argued based on those issues which are framed. After this comes the stage of summoning and attendance of witnesses as under Order 16 of CPC. This stage is about informing and calling the witnesses of the parties to the court. Both the plaintiff and the defendant who want to call their respective witnesses to the court have to first submit their lists of witnesses to the court within 15 days of framing the issues. Next comes the stage of hearing of suits and examination of witnesses under Order 18 of CPC.
Call the first witness.
The court hears the say of both the parties, but to avoid the dilemma of whom to listen first, the court follows a technique. Generally, it is the plaintiff who has the right to begin. Means it will be generally the plaintiff and his or her witnesses to whom the judge listens first. But this point has an exception. Under Rule 1 of Order 18, if the defendant admits the facts alleged by the plaintiff but contends that either in point of law or due to some facts claimed by the defendant, if the plaintiff is not entitled to any part of the relief which he seeks, in such a case the defendant has the right to begin. Even the chief examination and cross-examination of the parties will take place during this stage itself. Okay, after both the parties finish saying their side of the story, submit their evidences and conduct the chief examination and cross-examination, the suit is then kept open for argument.
Your Honor, मुल्जिम सिर्फ ड्रग का नहीं बल्कि मौत का व्यापारी है। यह कानून का ही नहीं बल्कि देश का दुश्मन है, समाज का दुश्मन है। That's all, Your Honor.
Well, after presenting the final argument, the process is then moved to the judgment stage. Order 20 of CPC states about judgment. After hearing the case, the court shall pronounce judgment in an open court either at once, that is soon after hearing the final judgment, or within 30 days from the date on which the hearing of the case was concluded. Once the judgment is delivered by a judge, a decree has to be prepared by the concerned clerk. Preparation of decree too comes under Order 20. The rules are 6 and 6A. A decree is an official order of the court. It bears matters such as the description of the parties and details of the judgment pronounced. Therefore, it has the force of law. After receiving the order or decree, the parties may make the appeal, review, or revision based upon the order. Next comes the final stage of the civil suit, which is execution of decree as described under Order 21 of CPC. This means to fulfill the obligation as directed in the judgment. So, finally the decree holder, that is the party in favor of whom the decree was passed, will be eligible to recover the gains from the judgment debtor, that is from the party against whom the order was passed. Amongst all these stages, we need to note one more stage, that is interlocutory proceedings. We know that generally a legal suit runs for several years. So to cope up with that, the court may pass temporary orders in between the course of legal proceedings. In other words, passing an order in an intermediate stage of the long legal proceedings. Such a provisional order or interim order or temporary order is called interlocutory order. So we need to remember that interlocutory order is not a final order. That is, it does not determine the final cause of action, but only temporarily decides some intervening matter pertaining to the cause. Well, that was about the stages of civil suit. This is my first video on the YouTube platform. I hope you liked it. Thank you.